Good morning, good afternoon, good evening, and welcome to all of those who have joined the session live or who will be watching this recording later. This is the fourth session of the educational and training series in the context of the 31st Vis Moot, brought to you by Africa and the Moot and with the support of our media partner, the Arbitration Channel. So for those of you who are new, Africa and the Moot is a nonprofit organization which is aimed at increasing equal representations and diversity in the Moot, specifically of sub-Saharan African teams. So my name is Ghada Arfaoui. I am a member of the Africa in the Moot Education and Training Committee. I am currently based in Bahrain, where I teach law and coach the Vis Moot team at the Royal University for Women. I am happy to be joined today by Abigail Sami, a fellow Africa in the Moot Education and Training Committee member. Abigail is a certified mediator and a qualified Kenyan lawyer specialized in data protection. And we are honored today to have Cesar Pereira. Cesar is a partner at Justen Pereira Oliveira Talamini in São Paulo, Brazil, and co-head of his firm's infrastructure and arbitration practice. He is a chartered arbitrator, a fellow, and the immediate past chair of the C.Arb Brazil Branch. He is a strong supporter of international mediation and arbitration moot competitions. He is on the board of directors of the Vis East Foundation and has been either arbitrating or coaching since 2011 at all editions of the Vis East and Vis Vienna. Before handing the floor to Cesar, I would like to remind our audience that they can use the chat function for any questions they have.
Well, thank you, Ghada and Abigail. It's wonderful to be here with you. It's a great pleasure to participate in this initiative of Africa in the Moot. And again, it's very good to be also with Arbitration Channel, which is a big supporter of CIArb in Brazil and great partner of all our initiatives here as well. One thing that you didn't mention when you were talking about my resume there in my connection with the moot is that I have also been a parent of a mootie. My daughter was a mootie about 5 years ago, and so I know personally not only from being or having been a coach, but I know personally what all of you who are mooties and who are interested in the moot are going through when you are preparing your memoranda and later when you are going to be preparing your pleadings for the oral arguments. It's a lot of work, a lot of suffering in a way, but a lot of joy, a lot of fun, and it's as you have always heard, this is definitely going to be the best thing you will do at law school. It will be a memory that you will cherish forever. So it's a great pleasure again to be here. Like always, the Vis Moot Foundation strives to prepare a problem that will bring about a very comprehensive learning opportunity for the students and for the arbitrators, for everybody connected with the Vis Moot. And this year is no different. We have a variety of issues that we can discuss, and we are going to focus today on discussing some of the substantive law issues, some of the topics that are related to the CISG, which is, as you know, is the applicable law in this competition, or is the and sometimes the issue is whether it is the applicable law, but it's what inspires this competition. I have prepared some slides that I'm going to share now, and so we can cover some of these various topics that are involved in this year's problem. And of course, please feel free to ask questions, and we will try to make this interactive if possible. before we move forward, I would like to thank two people for helping me put together this presentation and doing the research that's involved in this. And these are my assistant, Lorenzo Miranda from Brazil, and also my Moot Alumni Association mentee from Uganda, Fortunate Kirabo. I'm very proud to be a supporter of the MAA mentorship program, and I have had mentees from Kenya. As I mentioned before to Abigail, a young lady from Kenya who I believe graduated from law school about 2 years ago, and in another mentee from Uganda. And so I believe this mentorship program is really something that if you're not involved with, you really should be, because it's a very good opportunity to engage with people from different parts of the world, both for the mentees and for the mentors. So I recommend that for everybody. So moving on with our topics, the general issue of this year's problem has to do with cyber attacks and some consequences of that with regard to the performance of a contract. And so we need to look at structurally at what has happened in this problem and what has happened between the parties in this contract. We have to look at liability. We have to look at exemptions. We have to look at some certain ramifications under the CISG of liabilities and exemptions, namely what's called the duty to mitigate the losses. So these are various topics that we will be discussing from now on. And the first thing is to at least remind ourselves of what this year's problem is about. Of course, you by now you have had the problem for about 3 weeks. You probably know it better than I do, and so but it's just a little reminder here. So this year's problem has to do with a contract in which the seller is Cesar X PLC, and that is the claimant. And Cesar X PLC is a company based in Mediterranean. And the buyer, which is the respondent in this case, is Visionic Limited, and they are based in Equatoriana. So basically, the parties signed a framework agreement, which, as you may know, is an agreement that provides the basic conditions and terms for future purchases. So that's why it's called a framework agreement. It provides you the framework, and the actual sales are concluded afterwards under those conditions. That framework agreement was signed in June 2019 for the supply of sensors made by the claimant. The agreement provided, and that's the key issue here, the agreement provided for a specific bank account for the payment to be made. And that was written in the framework agreement. And so that's how payment should be made, right? The parties subsequently amended the agreement in March 2022 by an email in which claimant requested payment was made to another bank account. Respondent complied, followed through with the obligation, and transferred the amount to the account that had been indicated afterwards. So in that email. So that's the basic idea. There was a change in the agreement. A new bank account was informed, and that's where the claimant, that's where the respondent, the buyer, deposited the price. However, the buyer, respondent, was later informed by claimant that there had been a cyber attack. And so that's where the cyber attack comes in. There had been a cyber attack in their employee's email, and that the email that the respondent received was a fake, had never been sent by the claimant, and so no amendment had ever been proposed. In light of that, claimant requested that a new payment was made in accordance with the agreement, and so claimant basically said there was no amendment, and so you had to comply with what was, respondent had to comply with what was in the agreement. The agreement was never changed. If respondent paid to a different account, that was respondent's problem, because payment had never been made in accordance with the contract. And respondent did not agree with that theory and did not comply with that request. And that's how we came to our dispute here. As you know, Procedural Order No. 1 provided that the oral arguments and the memoranda will deal with a specific list of topics, and for the substantive part of the discussion, we have to deal with item C here. Is claimant entitled to payment of either the full amount or parts of the amount due as payment under Purchase Order number 9601, or can respondent invoke a violation of a contractual information duty or obligation, or rely on a provision of the CISG so there are three avenues here: an information duty, an obligation, or an information duty or obligation, or rely on a provision of the CISG to either entirely or at least partially defend itself against the claim for payment. So basically, what we need to do is, in this situation here, is there anything that the respondent can do to avoid payment, or is claimant entitled to payment of either the full amount or part of the amount of the price? Okay, and so you can imagine that the first thing we have to talk about is how can a contract under the CISG be amended? Because that's if there had been no amendment, there would be no question, right, about whether respondent had complied or not, because it's clear from the original provision in the contract that the bank account used is not the bank account that was in the contract. And so we need to understand whether there was or not a contractual amendment. And so how do contractual amendments happen under the CISG? The first thing we need to understand is that there is a general rule under the CISG, Article 11, that provides for freedom of contract, freedom of form. And so the CISG provides that a contract of sale does not have to be concluded or evidenced by writing. And there is no other requirement regarding form. And so it may be proved by any means, including witnesses. So that there is an absolute freedom of form. That freedom of form, even though I have just said that there is an absolute freedom of form, that freedom of form is not entirely absolute, because there can be a reservation, and I'm sure somebody is going to ask for clarifications if there is still time for that, asking whether any of the countries involved had made an Article 96 reservation under the CISG, which is the provision that allows a party to require that contracts under the CISG are concluded in writing. And so if there is that reservation, then Article 11 does not apply in that way. And there's another interesting aspect of Article 11. Article 11 is not mandatory, which means it may be derogated by agreement of the parties. And so those are things that you should bear in mind. But as you can see, Article 11 does not deal with amendments, right? And so let's go to the amendments provision, which is Article 29. And Article 29 says a contract may be modified or terminated by the mere agreement of the parties. So the conclusion that we take out of this provision is that an agreement of the parties may change an existing contract. And how do you understand whether there has been an agreement of the parties? You go to Article 11, for instance, and understand that any agreement of the parties that can be proved by any means is an agreement that is also able to modify or terminate a contract. And so the general idea is that the same freedom of form that applies to a contract applies also to an amendment. However, it's possible, and this may not be relevant to our case here, but it's possible under Article 29.2 that a contract in writing contains a provision requiring that any modification or termination has to be in writing. And so if that exists, that must be complied with, unless there is, and that's the final part of Article 29.2 here, unless there is some type of conduct that leads the other party to believe that the party asserting this rule had waived for some reason the right of modification by writing. And so you can see that the CISG in general is very much in favor of freedom of form, in favor of making any type of agreement enforceable. And so it's exceptional to have form requirements in the CISG. Now, as I said, the provisions of Article 11 that deal with freedom of form, they also apply to modifications, to contractual amendments. And actually, the whole system of contract formation under the CISG applies to contractual amendments. And so rules such as Article 14 and 11 and 18, Article 14 deals with offer, Article 18 deals with acceptance. That structure of offer and acceptance is also the structure that you need to see in an amendment. Those amendments can be done in writing, can be done implicitly, can be done even orally, except if Article 29.2 applies. And rules like Article 8 and Article 9 CISG, which deal with the construction of a party's conduct, which is Article 8, in usages and practices, which is Article 9. Those are rules of interpretation of what the parties wanted to agree upon, right? And so all those rules, they also apply to contractual amendments. And so we need to keep all that in mind when we look at this specific case to understand whether there has been an amendment or not. So Contractual amendments, they can basically cover anything in the agreement or most aspects of the agreement. And we can amend the goods, we can amend the price, the payment terms, the form of delivery, and basically anything. For our purposes here, it's perfectly acceptable for a contractual amendment to deal with the price or how the price is going to be paid. So it's from that perspective, there is no difficulty in accepting the email that happened here as a change in the contract. This case here, I believe, will be used in the competition, and it's a Russian case, and it's a case in which the parties implicitly amended the contract to specifically replace the obligation of payment by bank transfer with an obligation of payment by delivery of promissory notes. And how did this work? It was not even not even an email like in this year's case. The buyer had transferred funds to the seller, but not the full amount of the price. And at the same time, it transferred some promissory notes in writing. So in those promissory notes were delivered to the seller, and the seller never objected to receiving those promissory notes as payment. The buyer sent them, and the seller accepted them and did not object. And by accepting those promissory notes and not objecting, the seller was considered to have implicitly accepted a change in the payment terms, so that the delivery of those promissory notes was considered to be a full payment of the price. And so you see that in this case here, what happened was precisely an implicit change in the contractual terms regarding payment by conduct, by the exchange of a letter sending those promissory notes, and the lack of any objection on the part of the seller. And so I think if we disregard the issue of the cyber attack, right, and if we think only about whether an email coming from the seller to the buyer, instructing the buyer to pay in a different way without any objection from the buyer, and on the other hand, with the conduct of compliance from the buyer, in theory, that could be an amendment to the original contract. This is a consequence of the freedom of form under the CISG. As I said, the provision of Article 11 is not mandatory, and so it can be derogated by the parties under Article 6 CISG. That derogation can be either expressed in writing or oral, but can be done expressly, or it can even derive from the parties' usages or practices in accordance with Article 9 CISG. And so if we can find, for instance, some type of usage or practice, in usage, the difference between usage and practice is generally that usage is something that's more related to the industry where the parties are involved. So things that behaviors that the participants in that industry usually adopt. And practices are more related to previous dealings that the parties may have had, what sometimes we call course of dealing, the practice that comes from previous businesses between the parties, or even previous engagements of the parties under the same contract. So you can think about, for instance, a contract like a long-term contract, maybe even this one here, a framework agreement that may have several different sales under it. You have the opportunity to have several different occasions to deal with the other party. In that type of permanent dealing creates a practice that becomes binding on the parties in accordance with Article 9 CISG. And so those are all things that we can look at to see if the parties decided to derogate from the freedom of form of Article 11. So just to conclude this first part here, these are some things that you can think about based on what I was talking about before until now. So was an amendment to the contract validly concluded? What is the law governing the validity of the agreement? And actually here I think we should, I think we should think not of the law governing the validity of the agreement, but governing the formation of the agreement. Because here, what are we talking about? We need to see what law governs the formation of the agreement and the formation of the amendment to the agreement. And as I mentioned, we need to look at the rules in the CISG regarding formation of the contract to understand whether an amendment was or not concluded. As you know, under Article 4 CISG, validity is outside the scope of the CISG. And so you will never discuss validity under the CISG. What we need to know is whether an amendment to the contract was concluded and what is the law governing the formation of the agreement and of the amendment. And in here, you can also you can also look at the prior dealings of the parties to see whether there could be prior practices that would limit the freedom of form given by Article 11 CISG. So you can look at the problem and see if there is anything there that you can use either to come to the conclusion that yes, the parties have absolute freedom of form, and so it's irrelevant how this email was exchanged because it's sufficient for amending the contract, or you can come to the conclusion that the parties did have certain prior practices that would require an amendment to have been done in writing or to have been signed formally by the parties. As I said, and this is one takeaway that I would like you to have is Article 11 is not mandatory. It can be derogated by the parties, and that derogation does not have to be formal. It can be by conduct, by practice, by usages, and so you do need to understand what the context of that exchange of email is. Now, you know, the topic here has to do with payment, right? So with the buyer's obligation of payment, which is the buyer's main obligation. And Article 54 of the CISG says that the buyer's obligation to pay the price includes taking such steps and complying with formalities as may be required under the contract. And so if the contract said that the payment had to be done by depositing money into account X, in principle, that's what the buyer has to do. And that obligation of payment does not require any request or any formality on the part of the seller. If all those things are already described in the contract, the buyer has to comply simply. Now, we know from the problem here that the buyer did pay a large amount of money. And we also know that the seller did not receive that amount of money, right? And so one key aspect of the discussion here is good faith, because in a certain measure, both parties are acting in good faith, right? One party was the victim of a cyber attack. The other party received an instruction and complied with that instruction. And so when you are discussing your case here, and when you're preparing your memoranda and your pleadings and everything, you can explore the idea of good faith from either side, and you can also be faced with the argument of good faith from your opposing side. And so this is probably going to play a large role in the discussion. But good faith under the CISG is very controversial, as you may already have heard. Article 7.1 CISG does provide for good faith as expressly, but it deals with good faith specifically in the interpretation of the convention. And so there is a lot of discussion whether good faith under the CISG can be used as a source of obligations, or if it's only some type of guideline for the interpretation of the convention. And there are scholars that argue both sides, and so you will find scholars defending very different positions with regard to good faith in the CISG. Professor Lisa Espagnolo has this article from 2007 in which she mentions that a variety of arguments relating to good faith in the CISG give it a very different roles. So it could be an aid to interpret the CISG, a general principle in gap filling, also a direct positive obligation imposed upon parties, in other forms of application of good faith in the CISG. But other scholars like Professor Ingeborg Schwente, Professor Pascal Hachin, they are much more restrictive with regard to good faith, and they say that Article 7.1 does not apply to the interpretation of statements made by parties of contracts, but it's a guideline for the interpretation of the convention. So you would interpret the statements of the parties or the contracts under Articles 8 or 9. They don't have anything in them related to good faith. But they also say that since the principle of good faith guides the interpretation of the rules that will provide for the parties' obligations, indirectly, the parties are also affected by good faith, because their obligation will be interpreted under the CISG with the idea of good faith in international trade in mind. And so this may not be very objective or precise, but it at least gives you an idea that it's not absolutely impossible to use or to invoke good faith when you are dealing with the CISG. And actually, some scholars are very much to the other extreme, and they say that it doesn't make any sense for you to apply the CISG to interpret, or to apply good faith to interpret the CISG and not extend that to the interpretation of a term in a sales contract or of a party's conduct. And so and that's the position of this Professor Ole Lando in a paper that was published in 2005. And so you will find authority either in favor or against the CISG of good faith in the CISG. And so this is probably a good topic for you to explore in your memoranda, in your pleadings. You just have to be mindful that this is very controversial, and so you shouldn't take good faith as something obvious. In some jurisdictions, good faith is like everywhere, right? And so it's a concept that applies very broadly, and so you shouldn't assume that that's the case under the CISG, and you should really look into the details and see how you can explore that, mindful of all the opposing arguments regarding this good faith. Now, the obligation of payment, they are normally provided in the agreement. The place of payment can be indicated expressly, or sometimes, as in this case, only as an indication of a bank account from the seller. And in one thing that's very important is that only the actual payment will discharge the buyer from its payment obligation. So the buyer bears the risk of loss or the risk of delay in payment. The buyer has to make sure that it complies with all the requirements for payment to be effective. And the place of payment, the place of payment is generally the seller's place of business at the time of payment, and so the buyer must pay attention to any information that may come from the seller regarding its place of business, because if the seller informs the buyer that it has changed its place of business, the original place of business will be inadequate for receiving payment. So if the buyer pays at the original place of business of the seller, it will be paying wrongly, and it will be liable for the lack of payment. So again, if you disregard all the discussion about the cyber attack, this is pretty much what happened here. The buyer was informed by the seller that the place of payment had changed, so it was now a different bank account, and the buyer had to comply with that. Otherwise, the buyer would be liable for not paying properly. And so this is something that you can think about. when you put yourself or yourselves in the buyer's shoes, right? So the buyer received an information, and it was a crucial information for the compliance with the buyer's obligation to pay. And so think about that. So again, what can we take away from this discussion? When respondent paid to the new bank account, was it not paying that in good faith in complying with Article 54? And if so, is that enough to discharge respondent from its obligation to pay, even if, because of all the cyber attack and all the other issues, even if the seller did not receive the payment? And is respondent's good faith enough to discharge a respondent from the obligation to pay? So this is something that we need to think about when we talk about good faith in this case. Now, here we are in the eyes of the seller, we are talking about breach of contract. Right? We are talking about whether the respondent complied with its obligation to pay or not. And the seller is saying no. The claimant is saying no. The respondent, the buyer, never paid. And so we need to understand how that works, breach of contract and the corresponding remedies. The breach of contract may lead to a variety of consequences, of remedies, which can range from specific performance to the avoidance of the contract in case of fundamental breach, and a claim for damages. And a claim for damages is basically available in any situation. And so under Article 62, which is the seller's remedies, it says that the seller may require the buyer to pay the price, to take delivery, to perform his other obligations, unless the seller has resorted to a remedy which is inconsistent with this requirement. So it's perfectly okay in terms of remedies for the seller to require the buyer to pay, which is what it's requiring here. Now, if you think about the buyer's obligations, if you think about the buyer's obligations, the breach of contract will be normally either failure of payment or a refusal to take delivery of the goods. So here we are talking about a possible breach of the obligation to pay. And as I said, the remedies are varied, and usually they involve specific performance, damages, or avoidance. And they can also be those remedies also can be combined. But the important concept with regard to remedies and to the consequences of a breach under the CISG is the concept of foreseeability. And so basically a party will only be liable for consequences that are foreseeable at the time of the conclusion of the contract. And in here, we need to be very careful about this idea of foreseeability, because it's not a matter of knowing whether the breach is foreseeable, but if the consequences of the breach are foreseeable. The consequences that are foreseeable may be included in the liability of the party responsible for the breach. The consequences that are not foreseeable are not under that liability. But for instance, if I enter into a contract with a party that has a very large chance, very good chance of breaching that contract, that has nothing to do with foreseeability in the sense of the CISG. It has to do with the kind of agreement, or with the level of trust that each party can have in the other. And so the fact that an obligation that the other party undertook, in which I knew it was not able to, or it was very likely not to be able to perform, that may not have to do with the foreseeability of the consequences of the breach, but with the substance of the agreement that was made between the parties. Here, here you can see some scholarly notions about foreseeability, and in its what I was saying before. Foreseeability should be examined on the basis of the parties' knowledge of the ramifications of a breach. And so what's foreseeable is what you can anticipate as being a possible consequence of a breach. And so you're not talking about the foreseeability of the breach, but the foreseeability of the consequences. Because basically what the foreseeability here has basically to do with what happens if I breach the contract to the other party. What happens to the other party if I breach the contract? And those consequences, those ramifications, were they foreseeable or not? Another aspect, which will be very important here, but is not directly related to foreseeability as exemption of liability, is the foreseeability of the cyber attack, the foreseeability of of a defect in the email that was sent to the buyer. All those are very important issues, but they need to be framed in a way that's not directly the idea of foreseeability for exemption of liability, but the conduct of the parties interpreted under Article 8 and Article 9 CISG. So that's basically where you would that's basically how you would view the foreseeability of cyber attack, or the foreseeability of a defect in the email that respondent received. You would need to see how that should be viewed in the context of the business made by the parties, in the context of the sector where the parties operate, in the context of electronic communications nowadays, in the context of usages, and so that I think Article 8 and 9 is where you would find the criteria, the guidelines to use the idea of the foreseeability of a cyber attack, or foreseeability of defects in the communication. So here we could think about whether the agreement was breached in a way that amounts to a fundamental breach, and if the claimant could avoid the contract for that reason. In what I was talking right now, could the cyber attack be considered foreseeable based on the alleged practices between the parties, the current reality of business in the party sector, the inconsistencies of the email? Was it foreseeable that there had been a cyber attack? And if so, how do you treat that under the CISG? Now, another aspect, and we are coming to almost to the end here, another aspect is the duty to mitigate the losses. And here, there may be something very important to discuss, because Article 77 says that a party who relies on a breach of contract must take such measures as are reasonable in the circumstances to mitigate the loss, including loss of profit resulting from the breach. And so, which party is claiming that there has been a breach? The seller, right? The claimant. The seller is saying that the buyer breached by not paying, and we need to see how the seller behaved, and if the seller took the measures that it could have taken to mitigate those losses. And because if the party fails to take those measures, the party in breach may claim a reduction in the damages in the amount by which the loss should have been mitigated. So we need to know if the seller mitigated, and if not, how much it would have been able to mitigate all the losses if it had taken any precaution. And it's interesting to see that, and Professor Schwenzer talks about this here, the duty to mitigate damages is not an enforceable obligation. It's actually a duty to be taken in the aggrieved party's own interest. And so the victim of the breach has this duty to reduce its own harm in order to claim damages. And so what happens is the victim is precluded from recovering any loss that could have been avoided, and that applies to current losses and also to potential losses. So that's a very under Article 77. That's a very important duty under the CISG, and we need to take that very seriously. In this Hungarian T-shirts case, what happened was that the buyer complied with its duty to mitigate losses by accepting a price reduction in the negotiations with the customers. There was a defect in the T-shirts, and instead of simply sending the T-shirts back, the buyer was able to sell them for a reduced price, and therefore it mitigated the losses and was able to recover the difference from the seller. Now, these two exemptions are very important in this case. The first is a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control, and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So here, what would the buyer say? Would say, I breached my, if you're saying I breached my obligation, let's accept I breached my obligation of payment, but I did that because of an impediment that was created by a third party, was beyond my control. I could not have been, I could not have taken that into consideration. The fact that someone would inform on behalf of the seller would inform a wrong bank account for the payment to be made, and therefore there was an impediment beyond my control, and I could not be expected to have acted otherwise. That is what Article 79 could be used for. In Article 80, says that a party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. So here, what we will have to understand is whether the seller did anything that could amount to an act or omission that caused the buyer to make the payment to the wrong bank account. So here, what could possibly be those acts or omissions? Maybe the lack of information about the cyber attack, maybe other possible conducts that the seller could have taken when it found out about the cyber attack, or maybe we will come to the conclusion that the seller was as much a victim of the cyber attack as the buyer, and therefore the seller never did or omitted anything that was the cause of the buyer's failure to perform, and therefore Article 80 may not be used. So these two articles, I think, will be very much in the spotlight in the discussions this year. And just as a comparison, you can take a look at this later. If you look at Article 77, mitigation, Article 79, impediment, in Article 80, interference, they have a different way of working. They have a different scope, but they are all important in this case. Now, one thing that's very important for this year's case is this provision here in CISG Advisory Council Opinion number 7, which deals with exemption of liability. And if you remember, and you don't have to remember, I will come back here. If we go back to Article 79, it talks about an impediment. And impediment sounds like something that's absolute, right? That you can either if you're able to do something, there is no impediment. If you're not able to do that, there is then it's absolute. It prevents you from doing anything. Then it's an impediment. But this Advisory Council Opinion number 7 says that a situation of hardship can also be considered an impediment under Article 79. It says the language of Article 79 does not expressly equate the term impediment with an event that makes performance absolutely impossible. Therefore, a party that finds itself in a situation of hardship may invoke a hardship as an exemption from liability under Article 79. And so, even if this wrong information about the bank account, it does not, if it's considered not to amount to an absolute impediment of performance, maybe it could be considered as affecting the form of performance in a way that could attract the application of Article 79 as exemption. So that's also something for you to think about. And in this section here of this commentary on the CISG deals specifically with the obligation to pay, and says the buyer may be exempted from liability if he proves that the failure was due to an impediment beyond his control, or if the failure to perform was caused by an act or omission of the seller. So it's basically what the buyer would have to assert in this case. And in the issue will be whether those facts can be considered as having interfered with the compliance with the obligation to pay. Basically, what you have to say, what you have to look at is the buyer had to pay to a certain bank account. It paid to a different bank account because of the email that it received. Was that wrong email an impediment beyond the buyer's control to perform the way the contract ordered the buyer to perform? And that is enough for Article 79. Or if you can say that not only that was an impediment, but that was attributable to the seller, then you can apply Article 80. Okay, this Clay case is one in which the clay here was the object of the sale, and there was a certain chemical element in the clay that the seller knew that the clay had, and it never mentioned that to the buyer, and so that increased the risks for the buyer. It ended up creating problems in the contract, and the conclusion here was that the buyer and the seller had to share the losses. And so the court here considered that both parties had contributed to the harm, and therefore they were not entitled to full recovery of damages. So here, as I mentioned before, you have to look at what the claimant did, if anything, to mitigate the damages caused by the cyber attack, and respondent. And here is an interesting thing to think as well. Well, I mentioned to you before a lot of things that the seller could have done, but we should also think about things that the buyer could have done. So by simply accepting this strange email and not calling to confirm, not getting any other source of information, by doing that, has respondent failed to act with the necessary care, and therefore contributed to the damages under Article 80 CISG. So could the claimant say that the respondent had to be careful, had to be cautious when it received that email, and could not have acted so carelessly in simply paying based on an information that came by email about a new bank account. And finally, 2 or 3 slides here about the cyber attacks and the impact of cyber attacks on contractual relationships. This is an interesting thing that you will all have to think about, and it goes beyond the CISG. And it has to do with how normal is for us to be cyber attacked, right? And so how cautious do we have to be? How alert do we need to be to that possibility? And also, what type of duty information do parties that are subject to cyber attacks have? Here, the problem has an interesting issue. According to Procedural Order No. 1, the data protection law of Equatoriana is nearly a verbatim adoption of the European Union's General Data Protection Regulation, GDPR. And the GDPR is very explicit in providing that if there is a personal data breach, that can cause problems to other people. The controller of the information needs to communicate the personal data breach to the data subject, to the other people, without undue delay. There is a lot of discussion about whether this specific email would be considered personal data, whether the persons involved are natural persons or not. But in addition to the discussion about the application of the GDPR or not, there's another problem here. No explicit laws exist in Mediterranean or Danube. The seller is based in Mediterranean, and so would we be able to require the seller to make this type of disclosure based on the law applicable at the place of the buyer, or is the seller subject to its own law regarding protection of data, of personal data? Under let's say tech law, the law that regulates cyber attacks and other tech issues, the right to information is a fundamental principle of the legal framework of that area. But we will need to understand, as I said before, how much of that is applicable to the seller in this case. And so, just to conclude, we will, as I was saying, we will have to understand whether the claimant is subject to the data protection law of Equatoriana, or if we can get the same level of duty to inform from another source, even possibly from certain CISG provisions requiring transparency or other forms of these duty to inform. And well, thank you very much. And so if you have any questions, if you have any comments, I'll be delighted to keep talking to you here. It's been a pleasure. Thank you.
Thank you so much for that. I think we have two questions in the chat. One with Conradus. In accordance with Article 11 of the CISG, what constitutes a valid manifestation of intent in international sales contracts and how it is affected by international factors? And before we answer that, also, Carlos, perhaps you could clarify on your question, which I assume was at the point when we were discussing duty to mitigate the risks, and whether it should be a post-breach analysis. Kindly clarify if you're still here. Thank you.
Okay. Well, dealing with Article 11, the interesting thing is that, well, Article 11 deals basically with freedom of form, and so it's just saying that any form of expression of intent is sufficient for the CISG. So you don't need to have don't need to express your intent in writing or in any specific form. If you text, if you send a WhatsApp, if you send a message on Instagram, if you do whatever, any type of communication, or even just the implicit communication by conduct would be enough. So that's what Article 11 means. Now, in order to understand what constitutes manifestation of intent under the CISG, you go to Article 8 or Article 9, and you understand usages and practices under Article 9, or you you understand what a party may want to convey by a certain conduct or language, either on a subjective manner, and that's the first part of Article 8, or under an objective approach, which is the idea of what a reasonable third person in the same position of the parties would have understood from that type of expression. And so that's, I think that's, I don't know if that helps, if that's what you're asking, but I think that's where you would find guidance about what is manifestation of intent under the CISG. So that you basically go to Article 8 for that. And about Carlos Salgado, if you were talking about mitigation of damages, as Abigail assumed, yes, that is post breach, but it's yeah, well, it is post breach because it's a reaction of the victim of the breach to the breach, right? In theory, you could have a situation of anticipatory breach in which you already anticipate that the other party will breach, and you may be required to take measures to reduce your losses due to this anticipatory breach also. So that in that situation, it would not be post breach, but it would be post realization that a breach is imminent, right? But in general, the idea of mitigating damages or mitigating losses is something that is required from the innocent party after the breach has taken place in a way, in a form of reaction to the breach. And again, if that's not exactly what you wanted to ask, please just clarify, and I'll be happy to go on.
I have a follow-up question. Sure. In that regard. It appears from the record, at least, that in particular respondent would like to use the concept of mitigation under Article 77, not to mitigate the damages, but rather to reduce its payment obligation. To which extent do you think that is somehow possible? And how does that differ from the situation you described under Article 80, where both parties at least contributed to the situation?
Yeah, that's very interesting, and it does apply to the obligation to pay as well, because it will not only reduce damages, but it will affect all the remedies that are available to the seller in this case, right? And so one of the remedies is the payment of the price, and if the seller could have reduced the loss represented by the lack of payment, it had the duty to do so, and therefore it cannot claim that amount as compensation because it could have avoided that. In this specific case, it's interesting really to see that it's different from let's say the T-shirts case that I mentioned, in which there was a reduction of price that the buyer could have was able to receive from its customers, and then the damages that the buyer was able to seek from the seller was reduced. There we were talking about damages, clearly. Here, when we talk only about the price, it may the mitigation of damages may be harder really to apply, because the seller might have been able to avoid the harm altogether, right? If the seller had informed the buyer about the cyber attack or anything, it could have avoided the wrongful payment made by the buyer. But it's difficult to imagine how exactly the seller would have done something to mitigate its loss and reduce the amount that the buyer would have to pay, because it doesn't seem to be something that could be reduced, right? It's either you have to pay the full amount or you don't have to pay the full amount. As you were saying, it may fall under Article 80 more than under Article 77, because it may be more an issue of both parties contributing to the breach, and therefore the tribunal would come to some conclusion about what is the level of cooperation from or contribution from each party, and we'll either split 50-50 or some other proportion. But it probably makes more sense to apply Article 80 than to reduce payment based on Article 77, and that may be also something that the seller could argue, right? That it's irrelevant to tell me that I had to mitigate the losses, because we're not talking about a loss, we're talking about something else here, and then it will be either Article 79 or Article 80. But it's very interesting. I think it's a very interesting approach, and it may be something that will render some questions from the tribunal in the pleadings.
Thank you so much for that. We still have more questions in the chat. We have the next one coming from Yasmin. She asks, if there is a merger clause in the agreement, would that prevent the parties from invoking any practices prior or during the performance of the contract?
Yeah, that's very interesting. The idea of a merger clause in CISG contracts is always one that's subject to discussion. In general, the parties can derogate from any provision virtually of the CISG, and so if there is a merger clause, that means the parties have agreed to derogate from Article 9, and then they are not bound by those usages. The thing is, a merger clause is a boilerplate clause, right? It's a clause that's already ready, and parties simply attach it to their agreements. In boilerplate clauses, you can take a look at the theory regarding boilerplate clauses, and they need to be interpreted with a certain caution, because sometimes they are superseded by other provisions in the contract, because sometimes they're just there. They just like copy and paste those boilerplate clauses. But when you look at the rest of the contract, at the context of the contract, or other provisions, you may come to the conclusion that it does not reflect the actual intent of the parties. And so that would be, let's say, the counterpoint to what I was saying before. If there is a merger clause, that would be a derogation of Article 9. But you need to understand if that merger clause actually reflects the intent of the parties or not, and to what extent. Yeah. I think there is another question from Helena. Is that
Yes.
it?
Yes.
Okay.
It reads, since the general contract law of the three countries are the UNIDROIT Principles, could we use one of its provisions as a source of the duty to inform, or refer to one of its provisions on good faith?
Okay, this is also very interesting. It has to do with the interplay between the CISG and domestic law, and which is also controversial in the, let's say, the answer would be that if the contract is under the CISG, domestic law does not apply, and you cannot resort to domestic law to as a source of obligations that are not under the CISG. So as a general rule, the UNIDROIT principles would only apply in the areas that are not covered by the CISG, and so you wouldn't be able to use it as the source of the duty to inform or of good faith if that is not provided for under the CISG. So, but that's, let's say, that's the strict application of the CISG, right? There are multiple references to situations in which parties invoke the UNIDROIT principles for gap filling. You could say that the UNIDROIT principles are part of the usage of the parties because that's what they expect, since all the three countries involved are UNIDROIT are subject to UNIDROIT principles, and so there are ways that how you could frame this, but in general you would not resort to domestic law in a contract based or under the CISG.
We have one last follow-up question. And someone said, true, claimant doesn't have a duty to communicate, but doesn't this case go beyond just implementing national laws and more concerned with setting a standard of international practice regarding cyber attacks?
Yeah, I agree. I think the question here is if we are all exposed to cyber attacks, shouldn't we all be alert to that reality? And but you see, this works both ways, because you can say, okay, the seller, even though it didn't have the legal duty to communicate because it's not subject to the Equatoriana law or something, it would have a general duty in terms of fair dealing or whatever to communicate the cyber attack to the other party. But on the other hand, you could say, look, we all know that we are all subject to this type of situation, and we need to be be cautious. And let's say all of us, we receive emails that look like malware, that look like viruses, and all the time. And we are all aware of that, and we are all cautious. We don't go out clicking on emails that you don't know where they came from, and so we're all mindful of the risk of being subject to something wrong in terms of electronic communication. And so shouldn't we conclude that the buyer had to be careful when it received a really strange email, even from an email address that was wrong, that was not the exact email address from the seller? And so isn't that obvious for somebody who's living in our day and age, with all the cyber threats and everything? And so I think that will be part of the discussion here. In one thing that you need to do is understand that reality and understand how to frame that under the CISG. And so, okay, let's say we accept that the buyer had that duty to be cautious, that the seller had that duty to inform, having been a victim of cyber attacks, because the seller obviously knew that that a cyber attack to his employees' emails could create problems to anybody who had communications with them. And so if we consider all that as true, how do we apply the CISG to that? And so so where do you go? Article 80, Article 79, Article 8, Article 9. That's the point, and that's the whole purpose, in a way, of the moot, right? To make you think and make you go through the CISG and learn how it operates, and try to understand how you can use it. Now, Helena asked a follow-up question here about whether there is okay, sorry, Ghada. You will probably
yes, I was going to read Helena's question. So could we consider that there is a gap in the CISG concerning the duty to inform about cyber attacks?
No, I don't think there is a gap, because obviously the reality can change so much. Now we are talking about cyber attacks, but we have the CISG was done in 1980, right? And so you can imagine how much technology and everything changed from 1980. 1980, there was no cell phone, there was no internet, there was not even fax. You can even imagine there wasn't even fax machines, which many of you probably don't even know what it is. And so fax machines appeared after 1980 and disappeared before now. And so the technology is completely different. And so the fact that there is a specific situation like cyber attacks not expressly provided in the CISG does not mean there is a gap. What we need to understand is how this specific situation works under the framework of the CISG. And we may come to the conclusion that, for instance, it is a situation in which we are all to which we are all subject right now, and in the lack of efficiency, in a way, to deal with that from both parties is a contribution to the breach. And then we go to Article 80, and it's right there. The this contribution to the breach is a factor to reduce damages. And it may be also a factor to consider when you're talking about price, because price here, the requirement of payment of the price is a remedy, right? And so it may be subject to the same type of rationale as calculation of damages in general, and so we may come to that conclusion, and we wouldn't need to fill any gaps in the CISG. We would simply apply Article 80. So I don't think there is a gap concerning that duty of information specifically of a cyber attack.
I believe this concludes our session. Thank you very much, Cesar, for this very helpful and insightful session. I believe all of our attendees have enjoyed it so far. With that, would you like to say anything to conclude?
Oh, just thank you. It has been wonderful. I really enjoyed it, and I learned a lot from our discussions here. And I hope to see many of you there in Vienna. And if when you're there, just feel free to come talk to me. It will be a pleasure to meet you in person.
Thank you, everyone.